What I would like to stress in the beginning is that the importance of public procurement in the EU legal structure just cannot be overstated. So it is really at the heart of EU law. It's at the crossroads of administrative law, public law, competition law. It has so many procedural elements. I really think it's at the heart of European Union law, and I'll explain this shortly in the beginning, and then I'll go to the description of some cases. So first of all, how do I see European Union law in general? Just 2 minutes on that, and so that we can see how I see the role of public procurement within it. So a group of scholars, and including our president, Leenaerts, and myself, we published recently a session, actually a selection of papers in the European paper series on autonomy of EU law. And I've been arguing, actually, that autonomy of EU law is a central element of legal reasoning. So the autonomy, the European Union is, the autonomy of the European Union is actually crucial to our legal system. Autonomy and the European Union legal system have a very distinct ontological and axiological character. So ontological is, we have a preliminary reference system, we have mutual trust and so forth, but then there's the axiological elements to our legal system, and that is obviously the rule of law, human rights, protection, transparency, equal treatment, and so on. So without autonomy, the EU would just not be able to attain its goals without its very distinct character. Now, where does public procurement come in here? Autonomy of EU law is actually not discussed much in judgments related to public procurement. However, that actually portrays that public procurement is so much in the center of the legal system that the autonomy of the EU legal order is actually so developed in this legal system that we actually don't have to debate it anymore. And, public procurement, it has all the key principles that actually make the European Union what it is: competitiveness, transparency, fairness, everything, equal treatment. So it is quite fundamental. Why do I have this hedgehog here in this picture? So this goes back to Greek mythology, actually. And Isaiah Berlin in 1960s actually took up Greek mythologies or Greek philosophers' idea that a hedgehog knows one big thing, the fox knows many things, but a hedgehog always defeats the fox by its one big defense, and this is the big idea that he has in his mind. And the big idea that European Union has in order to promote its goals and values is the idea of autonomy. So it is quite central, and the European public procurement is actually a microcosm of EU law here. So, but going into the cases, how does this all relate? So there's so many principles we have to take into consideration in every case in public procurement, and the balance is struck every time anew. We have here first an interesting case of European Commission versus Republic of Poland. It's a judgment of the Court of Justice from last September, where again, all these principles were weighed and discussed and so on. But let me just go into the details of this case. So the Polish national legislation foresaw exemptions on public procurement, so no public procurement procedure needed, concerning contracts for the production of certain documents, printed matter and stamping and markings. So there was a direct award possible of the contracts relating to such services. Now, the Commission brought an action for failure to fulfill obligations against Republic of Poland, and it believed that by adding to national legislation these exemptions on public procurement concerning these contracts, it violated the Directive 2014-24. Because the Polish legislation actually provided for a direct award of the contracts relating to these services to a company in which the state was the sole shareholder. Now, Poland actually brought up many arguments in its defense. One was ensuring continuity in the supply of official documents. it was sort of arguing, all sorts of public policy exemptions here, that it is necessary to have a direct award to ensure the efficient conduct and security of elections, to ensure the protection of the security of the documents and information contained therein. So the court actually rejected all that. It said that Poland simply was not able to prove that this was necessary, that in order to attain all these public policy goals, it was actually necessary not to start a public procurement procedure, but to award the contract directly. Here, the court also mentioned a case, Commission versus Austria, State Printing Office from 2018, which you might know. The court said that if you need to protect the confidentiality, you can actually ensure secrecy and at the same time still have a competitive public procurement procedure. So, so Poland went too far here with this regard. However, the court also stressed that certain specific documents in question, so documents relating to the members of the military police that are really at the core of, let's say, national security of Poland, that those do present a direct and close link to the objective protection of national security, and hence the direct award was possible. So let me move on to another case, and that is a case of the General Court, actually. Direct action, 263. It's an Inivos case. Interesting, I think, on the facts, but particularly, I would love to hear your opinion, possibly later on, what you think about the outcome. So, so it was an action for annulment brought before the General Court by Inivos against the European Commission. The applicants are active in the field of specialized medical technology. And during the coronavirus epidemic, the Commission was set to deploy some robots, UV light robots, for the disinfection in hospitals. And due to the urgency of the situation, they used a negotiated procedure without prior publication of a contract notice. So there was just no publication. The applicants became aware of a Commission press release announcing that it intended to purchase 200 of such robots. And since neither a contract notice nor information concerning the award decision had been published, the applicant sent a letter to the Commission questioning whether public procurement rules had been followed. And they asked the Commission to suspend or terminate contracts, revoke award decisions, and to repeat the procedure. However, the subject framework contracts had been concluded and their signature was announced by contract award notice. So the applicants actually introduced an action for annulment. First, they demanded annulment of the decision to actually use the negotiated procedure without prior publication of a contract notice. However, this was declared inadmissible by the General Court. So the decision not to actually go through the regular procedure, but to use the negotiated procedure, was declared inadmissible. So why was it declared inadmissible? So interesting enough, the General Court concluded that this decision was actually a preparatory act and not the challengeable act, and that it did not affect the interests of the applicant in any way, because it actually did not prejudge who would actually get the contract. So what the court concluded was that this act was, as I said, purely preparatory in nature, and that the attackable act, so to say, was the actual award of this contract later on, which happens obviously later on. So, so a very interesting conclusion. And then the second head of claim was the applicant sought annulment of the contested award decision, of the second decision, so to say. But this one was also found to be inadmissible by the General Court. Just to say, I don't know how much you are aware of the admissibility rules before our courts, but for individuals, it's not so easy to actually get to our courts, because they have to show first legal interest, and then they have to show direct and individual concern. This is unlike for the privileged applicants, institutions, member states, and so forth, who don't have to show, any standing or interest. So, so it's actually pretty difficult. And here on this account, the applicants actually did not succeed. Even when they were seeking annulment of the award decision, the court concluded that they were inadmissible. Why? So the court said that they did actually manifest the direct concern, so that they were directly affected by this act of the award to another company. Why? Because they were active in the relevant market. However, they were not individually concerned, and these two conditions are cumulative for standing, because they have not proven that they actually fulfill the exclusion criteria. It was many criteria such as production capacities, how many robots they make for a year, and so forth. So, so did not succeed on that. They also claimed damages. It's interesting, actually. So the court rejected all of their pleas, but then on the damages, it went into the merits of the case, but they did not succeed that there on this in this plea and on this ground either. So here I think you can see that, I mean, there's a question of transparency quite clearly. Does the commission have to make it known that it's using the negotiated procedure? Is this an act that individuals could attack? The court said no. So that's, I think, quite important and also subject to discussion. So, all right, let me move on to the next case. This is another preliminary reference case the preliminary reference coming from Latvia here, Dobeles. I hope I'm pronouncing this correctly. So very interesting. I mean, there was an open tendering procedure in Latvia regarding public passenger transport services. The applicants actually challenged obviously the award, but also they challenged the provisions of the tender specifications due to alleged unlawful compensation mechanism, and I will explain that in a second. So the Supreme Court of Latvia actually referred the question for preliminary ruling, and the question was, may member states, in the context of public service contracts, establish a compensation mechanism that leads to the transfer of risks linked to changes in cost to a provider of passenger transport services, thereby bringing about a risk of undercompensation as a result of the increase in some of the costs. So what happened was that this contract was totally not profitable. So there was actually undercompensation, and is this actually legal? That someone who gets the contract is actually not properly paid for it. I think it's very interesting, again, who should be taking the risk? Are we talking about free market here? Is it different if it's a public service or not? So what are these goals of, of public procurement law and of the European Union in general, as I said in the beginning? How do we actually reconcile all these competing interests here? The Court of Justice actually concluded that undercompensation should totally be allowed. Why not? I mean, it said automatic coverage of all costs associated with the performance of a public service contract does not contain incentives for greater efficiency. So, if you're on the market, basically, you just need to, carry the burden of not being compensated properly. Why would this have to be different when you're, contracting with a contracting authority, with a state municipality and so forth? So, and also with this, with a different decision, give proper incentives for efficiency of these operators, of these contractors, if they knew they would be compensated anyway. So I think, the court gave some reasons, very interesting judgment, I thought. It also said that competitive tender procedures have in themselves the effect of minimizing the amount of compensation, avoiding not only excessive, but also insufficient compensation. So basically, the market should solve this. And thus, national authorities are not required in the context of this procedure to automatically compensate. Because they said there should be indexation and so forth, which was not foreseen in the tender documents, but the court obviously said that it is just not needed. So You know, another subject of discussion, and I would love to hear your opinion on this as well. Now, another case, which is interesting also from many perspectives. Obviously, I'm just, you know, rushing through so many cases and just giving you, you know, some ideas of what is interesting here and there. And I'm sure that, you know, throughout the day you'll go in more depth. And, you know, I'm also happy to discuss this. But this case is also very interesting. It's OHB system versus the European Commission. Very big contract. I think it was, you know, the offers or the tenders were about 800 million euro each. And this is also a reminder of the huge importance of public procurement to our societies. I mean, we spend like roughly 15% of our GDP goes through, you know, public procurement contracts. It's really amazing. I mean, this is just another element that makes this this field so fascinating and important for, you know, how do we actually spend our money, and you know, do we respect all the principles which are central to EU law? And obviously, it is also a field that is prone to corruption. But I'm not talking about this within the, you know, within this case. It's just to mention that this case shows how important these contracts are. So, but let me go back to the, you know, to the facts of this case. So, so there was a tender procedure for the supply of transition satellites in the context of the Galileo program, which I'm sure you all know. So three tenders were selected actually, and then there were different phases. And the European Commission decided not to accept the applicant's tender. However, what happened, there was a factual element which I think is really central to this case, and that is that prior to the adoption of the contested decisions, applicant wrote a letter to the Commission saying that its ex-CFO had been hired by the competitor. And it said that actually the competitor, that the Commission should do something about it because there was a serious professional misconduct on the you know, basically by the exercised by the competitor. And it sent a letter to the Commission, and it's the applicant said we have to investigate, reevaluate. Our CFO left, and allegedly, you know, sort of transferred some information to the competitor, who then succeeded. Interesting, you know, enough, basically, obviously a company can be excluded for if it is guilty of serious professional misconduct. It is a ground for exclusion. However, what the General Court concluded was that the applicant simply did not prove that there was any professional misconduct on the you know, on the side of the competitor. Basically, yes, the CFO did change jobs, so to say, but there was just no proof given that within the sphere of the competitor there was professional misconduct. So I think this also shows an element of free market. Basically, you know, people can go from, you know, from one company to the other. But if you allege that a company who actually recruited someone, you know, if you can accuse them of professional misconduct, then you have to actually give quite a lot of proof. So, so the applicants obviously did not succeed. The European Commission did not have to investigate or have to do anything about it, or even investigate, let alone find that there was any professional misconduct. Okay, so next, another interesting preliminary reference question coming from Portugal. So case C6622. So, you know, it's a mix, obviously. You know, the first case I showed you was the Commission versus Poland infringement procedure, and then there's a mix, you know, of preliminary references, direct actions. All are fascinating in its own way. This is another preliminary reference question. So there was a public procurement procedure for the purchase of, I would not even know what these spine sleepers are, frankly. Some rods intended for use in the railway infrastructure sector, basically to build railway. And the company actually that won the contract was previously fined by National Competition Authority due to a breach of competition rules in another public procurement procedure. Now, this was actually a grand chamber case. So this would actually make it obviously a very important case. I'm going to tell you first the reason why I believe the Court of Justice decided for the grand chamber before I go into to what it actually decided. I think the court actually changed its jurisprudence in this case vis-a-vis some older cases. I have the numbers here in case you're interested, but you can look it up also in the judgment. So the older cases were C4118, C395/18, C21020. So it was quite an established jurisprudence that member states do not have to transpose facultative grounds for exclusion, which are referred to in the first subparagraph of Article 57 of the directive. So, and in this case, it changed its mind, basically. I would say correctly, frankly. I mean, because the decision whether to exclude or not, or to use it, the facultative nature of those exclusion, the decision whether to use them or not and how to use them, this should be for the contracting authority, not for the member state. So even if the grounds for exclusion are facultative, the court now said, well, member state has to transpose them. So I think the reason why this was grand chamber is actually not so directly linked to procurement law, but is actually, it has a more horizontal dimension that even if a directive offers basically, some options, member states still have to transpose them. And I think that is correct. But then, of course, the Court of Justice went into the merits of the case, into the facts, and it concluded national legislation which limits the possibility to exclude a tender due to the distortion of competition rules in the public procurement procedure cannot be limited to the procedure in which this type of conduct arose. Meaning, the Portuguese legislation actually said, okay, if someone violated competition rules in a particular public procurement procedure, you can exclude them in that procedure. But that should not be a reason for exclusion in subsequent procurement procedures. And the Court of Justice said, well, here, Portuguese provisions are actually going too far or are just not in line with EU law. So basically, an exclusion can happen also in subsequent procedures. And then there's a question of there was another question actually of Portuguese law, whether it is in line with EU law or not. And that is, so does national legislation, the Portuguese legislation here, which confers the power to exclude economic operators from public procurement procedures on the grounds of a breach of competition rules, is this the competence solely of the National Competition Authority, this exclusion competence, okay? And the Court of Justice said, no, no, no. Also, a contracting authority can actually decide for the purposes of procurement procedure that someone has violated competition rules, and for this reason, they can be excluded, in any procedure, basically, not just in the procedure where this happened. So, couple of more minutes just to tell you, there's so many fascinating cases, and this one is actually really fun in my opinion as well. So I think we've all taken language courses, for those of you who work in the institutions, institutions promote this, heavily and widely, as you all know. So you have here in the picture, I think a book, French or something, and a coffee. But what happened here was, I don't know, but this is particularly interesting for those of you who are Spanish here, possibly. So the Commission launched a public procurement procedure for providing language training. And one lot was also reserved for learning Spanish. So, but the Commission actually, in its contested decision, awarded this slot to another tenderer. So not to Instituto Cervantes, which I'm sure if you're Spanish, you know it. It's like, it's like Goethe Institute of Germany, or I don't know, the British Council. So it actually promotes the Spanish language, worldwide. But the Commission gave the contract to a non-Spanish competitor. But so basically, what was and the applicants raised many pleas. Very interesting case. we can go into, or maybe you can go into the details later on. But I think what was one important dimension or interesting dimension, and I think very relevant from the development of technology, how do you submit tenders, was the issue of the applicant standard was partly submitted by hypertext links. So, and the commission said, we cannot accept that. You know, this is just not the way to accept it. We have an e-submission system. And, you know, hyperlinks, you know, can they even modify this? Can the tenders modify this after they've sent it? So the commission actually said, no, we're not going to look into those documents at all. And they did not. And obviously, and this was also possibly one of the reasons, I don't want to speculate, why Cervantes did not get the contract. But the general court then said that, you know, what the tender specifications say is that the tender must be uploaded directly to the e-submission platform, and only documents for which that process was followed form part of the tender. And hypertext links, such as in this present case, are thus not permissible. So that's the general court concluded that the applicants did not follow the tender specifications. And of course, the courts also raised the question of equal treatment, you know, equality, equal treatment, one of the fundamental goals or principles of the European Union and of public procurement as well. So the general court concluded that e-submission platform actually ensures the contracting authority can retain control of the document submitted to it. And so there is no chance of modification, and it does ensure equal treatment. So the system as it functions with the commission is fine, and it does not foresee anything else. So interesting case, I think, from the perspective of development of you know, technology and how can you actually submit tenders. Because Instituto Cervantes seriously thought, you know, let's just give them a hyperlink and that should work, but it didn't. Okay, but of course the appeal was introduced, and let's see how this goes further. Now, then there's a case 303/22, and that's actually probably the last case I will address because I think we have a couple of more minutes. So another preliminary reference question coming from the Czech Republic. So there was procedure for the award of public contract for the expansion of the function of the traffic control center. So basically something to do with traffic lights. And there were two bids, and the one who lost, you know, brought the case to the referring court. And the question here generally was whether, you know, I mean, the court actually concluded here that, I'll just read it out in order to give you an idea. So the national Czech legislation actually prohibited the contracting authority from concluding a public contract until the body of first instance, which in the Czech Republic was not judicial in character, ruled on the review of the decision to award that contract. I mean, you know, there's a standstill period that has to be respected after the conclusion of the contract. And here, in this case, so under the Czech legislation, they had to wait for the decision of the non-judicial body for the actual signing of the contract. And the court said, well, this is actually totally fine and in line with our directive, as long as there is a judicial review possible against the decision of this non-judicial body. No, so just, I mean, I was talking about balances, striking a balance, and you know what to do in a particular case, and I think here the court really, you know, sort of combined all the relevant interests somehow into this decision. So those of the successful tenderer, you know, you cannot wait indefinitely for the signing of the contract, quite clearly. Interests of the contracting authority that also cannot wait, you know, just forever to sign the contract, but also of the unsuccessful tenderer. So, you know, even if it was a non-judicial body, okay, we can wait till there. But, you know, if there's a subsequent judicial review, this should all be fine. And so, yeah, so because otherwise, you know, efficiency of public procurement procedures are also, you know, is also kind of an important element in this whole debate. if things drag on forever, obviously it's not good for our society, for our economy, you know, for the whole system. Even, you know, legal certainty, which is quite important in the European Union, could be harmed by, you know, extended procedures just as well. So I think taking all the relevant interests into account, you know, going back to what I was saying in the beginning, all the principles, they really combine in this, in public procurement, you know, from all sides of the story of, you know, of the European Union. So I think it's really an interesting microcosm, and this is why actually public procurement is close to my heart. One of the, you know, areas of law. It's really fascinating. So let me just say thank you for your attention, and happy to answer the questions to the best of my ability, and also particularly in view of the fact that I'm talking in my personal capacity and cannot say much more on some cases, particularly in which I was involved. Thank you.